council's aware of that. We did note there's not a court reporter appearing today, but we've confirmed we've got an audio signal. The Zoom software should be picking up what's being said, as well as I'll confirm with the court clerk. The court's FTR system is working in the courtroom. Is that correct, Madam Clerk?
Yes, it is.
Okay, and are you hearing us loud and clear in the courtroom for that audio signal?
Yes, I am.
Okay, thank you for confirming that. All right, council, the timeframes we've got in Idaho Code 1927-19 put us on a very shortened schedule here, which I'm concerned about, but do want to hear from council. The deadlines I've calculated would be just looking at that statute under 1927-19, 7 and 8. This matter is supposed to be decided within 90 days of the filing of the petition, and that's going to put us at October 15th. If the court determines there's an evidentiary hearing required, I'm going to have time to prepare written findings of fact and conclusions of law. And the state, under the regular post-conviction statute of 1949-06, has 30 days to file a response date, which puts the time I have calculated there at August 16th. So maybe the first initial starting point would be, Ms. Blake, an inquiry about where you stand in terms of, is a response going to be filed? And if so, do you have a time frame in mind, noting that the standard deadline would put it to August 16th?
Yes, Your Honor, the state is intending to file a response. I think at this point, I would say we'll try to get it done before the 16th, but we may be looking at closer to the 16th for the actual filing date on that. But we do intend to file a response and we'll have it done within the deadline.
Okay, thank you for that. Mr. Thomson, I would note, in addition to the petition, there's already been a notice filed that there's an intent to file a follow-up petition and a extensive list of additional information you'll be seeking in order to file an amended petition. I'm going to have to go through determinations, of course, number one, as to whether or not to permit an amended petition, and then number two, on the extension of any deadlines. And I will note the statute has some of the strongest language I've seen anywhere in any rule or statute in terms of extending deadlines here. Under 1927-19 sub 8, I would have to have a showing of extraordinary circumstances, and I would have to make a finding of impossibility, which is pretty unusual. And then finally, I would have to have a confirmation from the Idaho Supreme Court if I were to grant any extensions. So, of course, at the outset, the court's presumption here is we are going to get this done by October 15th, the 90-day time frame. I need to get a scheduling order out initially, and if you want to be heard on the issue of the time frames we're looking at under that special statute that governs this proceeding, I'll allow you to make some comment on that at this time.
Thank you, Your Honor. If I can just have ask for Your Honor's patience for a minute and sort of lay out what is going on our end. I wanted to reiterate, obviously this is not lost on anyone in the room, but we come into this case, the only ones in the room that aren't intimately familiar with this case, and we're representing Mr. Daybell as new counsel. And that's separate counsel from trial counsel, as is sort of set forth in Criminal Rule 44.2 and 44.3. So everyone in this room, other than our office, has been living and breathing this case for over 3 years, at least since the indictment. And we have an incredible amount of work to do from our perspective, just to get up to speed, just to catch up to where the county council or the state's council is at today. So I wanted to just briefly fill you in on where we're at in anticipation of sort of asking for for that extension is contemplated in 1927, 1908. We do believe it's impossible to get this done on that timeline. And we're happy to file a motion to that effect if necessary. So this is an unprecedented case for our office. We've never seen anything this size before. Mr. McCarty and I also have 6 other open capital cases currently, and we still have an attorney vacancy in our unit. What we received on the date of our filing from Fremont County is 6,592 pages of transcripts and 10,246 pages of record. All of the trial exhibits that were able to be sent via flash drive, less any of the physical evidence. And that's just in Mr. Daybell's case. That's to say nothing of Lori Vallow Daybell's case from 2023, which we believe is incumbent on us to obtain at some point, since Mr. Pryor was privy to that entire proceeding. So as successor counsel, we have also attempted to obtain our client's file. We've received approximately 14 terabytes of digital materials from Mr. Pryor. We didn't even originally have the server space for a file of this size in our office. We've been told that it is the unexpanded size of the zipped files, and that that is likely to increase as we expand the unzipped files in order to access them. And so for those of us who are somewhat unfamiliar or operate in this new realm of terabytes, I've been converting that, and it's the equivalent of 20,000 compact discs that were delivered to our office. So we are having to completely reinvent our processing and indexing procedures due to the volume of the material we've received in this case. We're in the process of contracting with outside tech firms or imaging firms in order to process, download, expand, index, and make readable much of the information that we've received from prior counsel. That being said, I can also share with your honor how we have approached the State Appellate Public Defender these cases in the past. We would normally, when we obtained this case, we didn't even have the record until after we filed that initial petition, either the record or the transcript. We were unable to observe or attend any of those proceedings. And so other than nominal, I guess, media reports, we were largely unfamiliar with any details of the case. We would normally read the record and transcript in a case upon receiving it, and then file an amended petition, as we've indicated with our notice, with our identified claims, and that would be filed from a more informed, better educated position. In the meantime, as we work through all of those materials, we're collecting as much information as we can and conducting our own investigation. We do not believe at this point that hardly any mitigation work was done by Mr. Pryor. And so we will largely be starting from scratch. In a normal case, we would sort of be piggybacking on what trial counsel had already accomplished. But understanding that this, once if we are granted the opportunity to file an amended petition, understanding that this discovery is discretionary in this case, in these cases, we've then made our motions for discovery orders, subpoenas, ducis tecum, depositions, and interrogatories. And then once that occurs, if any of those are granted, we have then asked to be allowed to file a final amended petition aggregating all of that information into a petition with all of the admissible evidence that we would want considered along with those claims that we've identified, along with the information that we've been able to uncover in our own investigations. So we also usually withdraw several claims that our investigations have not borne out at that point. In the past, in other cases, we have waived the state's requirement to file any dispositive motions on the original petition after the amended petition, and instead suggested that the state not file a motion for summary dismissal until after the final amended petition had been completed and submitted with all of our attached materials. At that time, then the case proceeds like a typical post-conviction, with your honor ruling on motions to dismiss, ordering evidentiary hearings, etc. In short, as of today, we still do not even know what we do not know in this case. Consequently, what I would be asking for, Your Honor, and I know this is a big ask based on what Your Honor has already set out, we would be asking to set out yet another status conference 90 days from now in order to return in early November and let Your Honor know exactly where we are at once we have a better sense of what we are dealing with, just with the sheer volume of the case. As we read 1927, 19:7, and 8, in the past, we have largely relied in every case that I've handled since 2010 on subsection 8 and showing those extraordinary circumstances that allow for the time to be extended with the Supreme Court's permission in the event that it would make it impossible to fairly consider defendants' claims in the time provided. Our position is that we will not, we filed a petition literally without knowing anything about the case, nothing about the case. And
Well, you knew enough to file a 254-page petition, so I don't know how you can say you knew literally nothing about the case if you put 254 pages together. And substantively, I mean, you know something about it. I think there's 48 pages of substantive argument, so I don't know that I would say you literally know nothing about the case. I don't know otherwise how you submitted that petition.
Fair enough. That is fair. I mean, we've outlined in our notice for need to file an amended petition what we were able to scramble and do in those original 6 weeks. We certainly have not, to date, read the trial. So we're in the position of filing claims about ineffective assistance of counsel without having either watched or read the trial. I guess that's what I mean by know nothing about that record. I will note that the sealed record comprised about 60% of the clerk's record, and that was not even available to us until just a couple weeks ago. I hear the court's frustration. I don't know what to say. We are under an obligation under 2719 to get a petition filed within 42 days. That is irrespective of what we're able to learn in that amount of time. So I will just explain by way of reference, it's clearly not binding on the court, that in the Eric Hall, just the last two post-conviction cases that we've handled, in the Eric Hall 2, or what they call the Hanlon petition, the final judgment was issued. And this is an original post-conviction where there was both a trial and sentencing. But that original final judgment was issued on January 3rd of 2008, and we didn't file an amended petition until April 7th, 2009, giving us 1 year and 3 months and 4 days to review the record and the transcripts and get those amended claims in.
And that was permitted or authorized by the Idaho Supreme Court pursuant to 2719-8.
8, yeah, and that was Judge Neville in Ada County. In Jonathan Renfro in Kootenai County, this was Judge Haynes. The final judgment was issued on November 7th, 2017, and we didn't file an amended petition until February 19th, 2019. So that was 1 year and 3 months and 12 days from the time of final judgment. And that was also permitted by the Idaho Supreme Court. Just by way of reference, I mean, this is cultural and past experience only. But in the Renfro case, again, that was a November 7th, 2017 case. We have still not filed a final amended petition in that case. It's now Judge Reese's case, as Judge Haynes is retired. But we are 5 years and 5 months on from the amended petition, and that has to do with discovery issues. In the past, the only reason I bring that up is because in the past, these cases are of such enormity and importance that we have been able to show extraordinary circumstances in these cases, just in order for post-conviction counsel to meet their obligations. In State versus Hall, 2013, the Idaho Supreme Court has indicated that there is a statutory right to post-conviction counsel via Criminal Rule 44.2 and 44.3. In capital cases, this is not true of any other case. And in that Hall case, they indicated that there is a right to the Sixth Amendment that attaches conflict-free counsel. And we believe that in order to be effective at post-conviction, we are going to simply need the time needed to review the materials of the case before we can intelligently and effectively submit an amended petition with claims that we can prove up with admissible material, which is our obligation under the post-conviction statute. We are in no position to do that either today or by August or by October. That I can adamantly declare that will not happen in that timeline. Meaning we will not be able to be effective in that time. And that's I know that's a legal determination for someone else to make, but that's my representation as Mr. Daybell's, I guess, learned counsel, as we are on the capital roster and approved to handle indigent cases in these capital matters.
All right. I'm going to note here, we are just in a status conference. It is part of the purposes for the court to gather an overview and perspective of counsel and where they stand on the timeframes here. So we're not arguing. Well, I've heard substantive argument here. I'm not considering today whether or not I'm going to grant a motion for an additional petition to be filed or whether I'm going to make any extension of deadlines. The suggestion that I set a status conference 90 days out, I can't do that without further findings. That would clearly violate 2719(7), which says it shall be heard and decided within 90 days. And then there's a process to extend that if I determine that it has to be extended and must be approved by the Idaho Supreme Court. So scheduling another just status conference 90 days out would run me afoul of what I'm required to do under the post-conviction statute. But it sounds like we are going to likely need to have a substantive hearing on that issue. Ms. Blake, in terms of timeliness and timeframes going forward as governed by the statute, do you have anything to add as we move forward? And what I'm considering here is just looking at a timeframe to schedule a motion to substantively take these matters up and determine whether or not we stay within the timeframes of the statute or have to extend them.
Yes, Your Honor. As indicated, the state intends to get a response filed within the deadline that's assigned to the state. I would note part of the problem is the state can't not file an answer or motion for summary judgment because, again, we're under those time constraints of having to file within 30 days. There's been no extension granted by the court. There's been no extension of deadlines granted. So that's still the time frame we're looking at. In looking under that 192719 subsection 8 that allows the potential for an extension on the case, there have to be certain showings made. And my read of it is that it has to be findings that are made under oath. So I guess where the state is at is if that is going to happen, we're hopeful that that will take place sooner than later, because that does obviously affect the state's filing deadlines as well. So right now we're looking towards filing it on or before August 16th. I recognize the court at this point is mandated to issue a decision within the 90-day time frame as well. So I think we would need to look at setting some kind of a hearing on this matter, whether it be a hearing or an evidentiary hearing. I do intend to file a motion for summary judgment on at least multiple of the allegations made. So I would be looking to get a hearing set on that. And then if there are any matters that are not summarily dismissed or that we don't ask for that on, I would think that we would then need to set a hearing regarding those matters. I recognize that's a short time frame, but right now, without any kind of an extension, the state's perspective is that's the time frame that we need to be looking at. So we would be asking those to be set sometime after August 16th to still allow the court to comply with the 90-day deadline that's currently the timeframe we're looking at here.
And Your Honor, just to be clear, the petitioner's counsel, if it were at all informative, would be willing to waive the state's obligation on that 30-day requirement to the extent that Your Honor would allow for such a waiver.
Okay, if the parties wish to submit a written waiver, I'll consider that. I haven't ruled on that right now. Again, I'm still within the constraints of the time frame under 1927-19. I'll leave the deadline where it is in terms of a state response. However, I do think that what we need to do is get a hearing scheduled that would allow for the court to fully consider whether or not an extension would be granted pursuant to subsection 7 and 8. And as Ms. Blake pointed out, those are the court can only consider information that's submitted under oath or pursuant to declarations. So let's go ahead and look at the calendars and figure out a time when we can hold a hearing to make further findings as to whether or not we stay within the timeframes under the statute, or whether or not I determine the impossibility standard's been met and submit that to the Supreme Court for their review. Mr. Thomson, I do take stock in your experience doing this, and where you've referenced those other cases, just for my reference, what is the time frame you've typically seen on a Supreme Court decision, either approving or denying a request for extension of the time?
Meaning the time that the Supreme Court requires?
From the time they are given the information, how quickly do you usually see a turnaround where they have either approved or not approved an extension?
Very quickly. In fact, in a successive capital post-conviction case that was handled just earlier this year, a couple months ago, in State versus Dunlap, which is down in Teton County, or no, I'm sorry, in Teton County, or Caribou, I'm sorry, it's Soda Springs. The response was the next day from
Okay.
the
Well, I figured they would act quickly on these. It's interesting to hear your perspective, though, since I have never submitted one to them before. So looking then at a date to get a time scheduled for a hearing. What about in 3 weeks on August 28th? And again, this would be an in-person hearing in Fremont County.
We would be available, Your Honor.
And that will work for the state, Your Honor.
Okay, why don't we schedule that hearing for 10 o'clock a.m.?
Your Honor, just to have all of our ducks in a row in anticipation of a hearing on the 28th, I'm assuming it would be helpful if Your Honor saw a motion and any attendant declarations from us before that.
Yeah, I appreciate that. I'm kind of putting the cart before the horse here. I'm presuming there will be a formal motion along with an opportunity to respond. So the 3 weeks is kind of tight, but again, we're in tight time frames regardless. So I would anticipate a motion to be filed, and I wanted to talk about scheduling, perhaps on scheduling for when you think the motion could be filed, and then if the state seeks to file any written response, set out a schedule for this hearing. So, Mr. Thomson, would you be able to have that filed, say say by either the 16th or the 19th.
Yes, I would appreciate the weekend. Meaning the 19th.
Ms. Blake, if there's a motion filed by the 19th, and again, this is limited to the issue of the timeframes under 2719, 7 and 8, and a hearing where the petitioner seeks to show extraordinary circumstances requesting a extension of the deadlines. If that's filed by the 19th, does that give the state adequate time to respond before hearing on the 28th?
Yes, Your Honor, I think it would.
Okay, why don't we say then, if you could have your written response filed by the 26th, then that'll give me a couple of days to review pleadings before the hearing starts. So, I'm not going to set out other scheduling orders. Again, the scheduling order right now is just governed by statute, but the hearing then will go out a notice, so August 28th at 10 a.m. A motion to be filed by the petitioner no later than, and I'm going to give you 5:00 p.m. on the 19th, and then the state's response 5:00 p.m. August 26th. And the hearing would be on the issue of whether or not timeframes can be extended, and then the court will make a determination if necessary after hearing argument.
And Your Honor, if I may inquire, do you still want the state to look towards getting a response done on the 16th? Do you want me to work that out with petitioner's counsel? Just as an inquiry where we are setting that hearing now.
Okay. In lieu of me making a finding, you don't have to. I'm still concerned again about being governed by the statute. If you have a written waiver that would make you feel comfortable and I think would comply with statute, that the petitioner is not going to hold you to that deadline, then I'll consider extending that based on a waiver of the petitioner of seeking to enforce the deadline. I would leave you to work that out with counsel. If you want to have another quick hearing on the issue of extending that, you think that needs to go on the record, I could call that up sometime before the 16th. But if you reach a stipulation, I'd be comfortable relying on that if you are, in terms of making sure you're not waiving any right by going past the deadline.
I was going to suggest my reaching out to Ms. Blake and submitting a stipulated waiver. And if Your Honor was okay with that, we may be able to address it in that manner.
Okay, if you do that and there's a stipulation, I would be fine to rely on that stipulation and allow the state additional time for a response.
And Your Honor, would it be fair in that stipulation if we arranged it to go up to the 28th and then the new date to be set on the 28th, meaning we would anticipatorily waive until Your Honor gave the state their deadline?
Yeah, that's what I was thinking. So if on the 28th, we're going to determine whether deadlines are extended, then I would be inclined to permit the state to file after that determination is made. And that would involve also getting the approval of the Supreme Court as well. So I would say that would probably put the state's response into September sometime.
Thank you.
Okay, I'll leave that to counsel. So I think that probably concludes what I want to bring up today, because this is just an initial status conference. We can talk in more detail about timeframes. Obviously, when we get to the hearing, I'll review the motion. Once it's filed, we'll set out a scheduling order with those deadlines for you on the 19th and the 26th. Is there anything further that the petitioner wishes to bring up at the status conference today, Mr. Thomson?
No, the only thing that I was going to bring up a couple things. One is normally in these cases, I know it's not required in civil matters, but I do generally indicate on the record. We've spoken with Mr. Daybell. He's aware about today's hearing. He waives his parent presence. I say that because there are occasions throughout post-conviction that we will ask for him to be present or at least available via Zoom out of the prison. And so I generally indicate that. Your Honor, there may be, and maybe I'll just wait until August 28th because a lot of this stuff will be obviated based on your Honor's ruling on the 28th. But we would anticipate filing a couple preliminary motions in the next couple weeks that I was going to just give folks a heads up on, and that was a motion to preserve records in this case, like a motion for an order for preservation of records, and then a motion for standing preparation of transcripts. But that's all we have at this time, Your Honor. Thank you.
Okay, I'll watch for those and see if there's any need to have hearing on those. They sound like standard orders that could be entered without need of any argument or hearing. Ms. Blake, is there anything further that the state requests to bring up today before we conclude?
I would just indicate the state is intending in getting a few motions filed of our own. One specifically that we will be getting filed would be to allow counsel, trial counsel to be able to speak with us regarding some of the issues that may be addressed and or have access to defense counsel's files. So we will be getting that motion filed. We may be filing a few others just so that the parties are aware and the court is aware that that motion will be coming. Outside of that, I don't have anything additional to address today.
Okay, well, I'll wait for those then. And as a note, I appreciate you bringing that up, Mr. Thomson. I should have addressed the non-appearance of your client here at this hearing, and at future hearings, I'll try to make a point to either have him present or acknowledge the waiver of presence if that's appropriate. In terms of getting things done and set, the court is governed under that statute again to make this priority proceedings. So I'll do my best to be available and have hearings, whether scheduled out on short notice or longer term, to make sure that all the hearings go as scheduled. And with that in mind, then we'll go ahead and recess and come back on the record in a in-person hearing on August 28th. We'll send out that notice for scheduling the hearing with the deadlines. And that'll conclude the hearing for today. So thanks for your attendance. All will be in recess.
Thank you, Your Honor.
Thank
You're
you, Your Honor.
Hey y'all. Well, Crusher and I are both. If you want to get some commentary, then you can hit the link in the here in the chat, and that'll take you to where Crusher is right now. And I'm going to go on and end this. Remember, justice for Tylee, JJ, Tammy, Charles, and Joe.